Hi everybody. Today's video is to talk about the importance of knowing the gifting rules surrounding Medicaid eligibility. Generally speaking, gifting is bad when it comes to Medicaid eligibility, just because the state, as I mentioned in some of my prior videos, has very strict asset thresholds that you have to get beneath in order to become eligible for Medicaid. Namely, you have to have less than $1,600 in assets in order to be eligible, but the state doesn't want you giving away your money to get down to that point, because if you had that money and you gave it away, you could have potentially used that money to pay for your long-term care costs. So to the extent you make a gift for the purpose of becoming eligible for Medicaid, the state is going to assess a penalty. And the penalty doesn't come in the form of, an actual dollar amount you have to pay the nursing home, you have to pay the state. The penalty is going to come in the form of Medicaid ineligibility. So they're going to say, based off of the value of the gift, you're going to be ineligible to receive Medicaid benefits for a certain period of time. And the larger the value of the gift, the longer the period of ineligibility. So what that means then is if you made a substantial gift and then you applied for Medicaid, you're out of funds to pay the skilled nursing facility. Medicaid has said they're not going to pay for it because there's this penalty period because you made a gift. The nursing home is now just not getting paid, and their recourse is to now go after the individuals that you made the gift to try to recoup that money from them and force them to pay the bill, the nursing home bill at that point. So it becomes a really bad situation, one you don't want to find yourself in. So in order to avoid that, gifting, again, in general, you can't gift assets away for the sole purpose of becoming eligible for Medicaid. Also important to know that Connecticut has a 5-year look back. That means when you apply for Medicaid, the state is going to look back at 5 years worth of financial statements. So 5 years backwards from the date that you apply for Medicaid. So that's 5 years worth of monthly statements for every single bank account, copies of deeds to real estate that you owned within that time, quarterly statements for IRAs and 401ks. Really, they want to see every single dollar that you've had in the last 5 years, and they want to see what happened to it, again, because they're looking to make sure you didn't gift it. So if you gifted your house to your kids, for example, a few years back, and it's within that 5-year window, you are going to be penalized and deemed ineligible for Medicaid for a certain period of time. Now, there is the option to cure the gift. So the people who you gave the gift to, they can give it back, and then you can spend the money down on your care, and that's one way to fix the problem. But again, if that doesn't occur, you're going to run into that Medicaid penalty where you're going to be deemed ineligible for a certain period of time. Also, another common misconception that I hear a lot is, well, it's okay for me to gift $15,000 a year or $16,000 a year, right? I've heard that that's okay. And yes, it is okay for gift tax purposes, but the gift tax rules are very different from the Medicaid rules. So Connecticut and the federal government have a gift tax out there that states that if you make gifts over previously it was $15,000 per year per recipient. As of January 1st of this year, it got bumped up to $16,000 per year per recipient. So long as you stay underneath that $16,000 threshold, there's no gift tax reporting requirements. You're not going to have to pay gift tax on those gifts. That is still 100% true. But the Medicaid rules are different. They don't care if the gift that you made isn't going to incur a gift tax. It's still, in their eyes, $16,000 that you could have used to pay towards your long-term care costs. So you're still going to run into that Medicaid penalty. So gift tax rules are different from Medicaid eligibility rules. They're going off of completely different playbooks. So just because there's no gift tax due doesn't mean there's not also going to be a Medicaid penalty. But also important to know, again, to keep focused on is that 5-year look back. If you made a gift 6 or 7 or 10 years ago and you're applying for Medicaid, even if that gift was for $10 million, it's outside of that 5-year window. So the state is not going to assess you a penalty for making that gift. So if you think you do want to make gifts or maybe substantial gifts of some of your assets, like either money or your house or other real estate, you really need to try to plan far in advance when you do that, because you want to make sure you get outside that 5-year window.